a very, very innovative and important webinar on Know Your Rights. And this is focused on a lot of what has been going on, not only in the congressional district, the 20th congressional district, but also everywhere you look, everywhere you turn. So today we have Lauren DeRosa she's the director of the Albany Law Clinic. She will be presenting a wonderful PowerPoint that is chock full of information that we all need to hear, and then we all need to know, and then we all need to act upon. We also have our representative, Congressman Paul Tonko. He is going to give some opening remarks. Thank you, Congressman, for being here, and I will pass it to you.
Thank you. Thank you, Cora. And thank you for this webinar, and thank you for the constituent outreach that we're so proud of in the district office. So good evening, everyone. And thank you. Thank you for your time and your attention to today's webinar. I think it's an important topic that we should all be concerned about. Over these last few months, we've seen increased ICE activity in our districts and across the nation. And we've witnessed masked agents scooping people off of the street and throwing people into unmarked vehicles, or have conducted activities at sensitive locations like courthouses and schools and places of worship, seemingly without any due process. That is causing widespread fear and definitely uncertainty. So these actions don't make our community safer. Ultimately, they undermine confidence in our judicial system and drive people even further into the shadows. And when we think about our very soul as a nation, we are a nation of immigrants and have always been a haven and a help to those in refugee status. And that need for information and education is why we're holding today's webinar. On that note, I'm so honored to be joined by today's presenter, Lauren DeRosa, Director of the Immigration Law Clinic at Albany Law School. And Lauren, thank you so much for being here tonight and for all your work to inform and defend our communities. Your intellect in this regard, your experience, your outright passion to make a difference just makes you a perfect guest this evening. And we just wish you well with your presentation. And for all who are on, again, thank you. It's not a webinar unless you join us. So thank you so much. So with that, thanks to all of you who have tuned in. And Lauren, the screen is yours.
Thank you so much, Representative Tonko, and thank you, Cora. I know that your office has been very busy, and constituent outreach is such an important aspect of what our representatives do for us. And I know that you have been fielding a lot these days. I'm really grateful for the opportunity to talk about ICE and just the process of ICE arrests and detention. What I am going to do is I'm going to share my screen, and I will hopefully share my screen. Let's see.
There we go.
Okay. So as I was introduced, I am the director of the Immigration Law Clinic at Albany Law School. I help law students learn how to practice immigration law. I've been practicing immigration law for a while now. I was practicing in the first Trump administration, the Biden administration, and now the second Trump administration. So I've seen the difference in the change in the way that the administration really matters, and the kind of smaller aspects of the policies really have an impact on the broader effect in the administration administration and enforcement of the law. Before I begin talking kind of through the content, I do need to clarify I am an attorney, but I am not your attorney. This is not legal advice. This is information. And I also want to note that there have been a lot of changes just recently within the past few weeks, and there will be changes and those will continue. It is chaotic. It is difficult even for somebody like me who sits every day in front of my computer all day and into the evening trying to keep up. It's exhausting. And so I think that that is the point. And it is difficult to keep up. And the information in this presentation will no longer be accurate at some point. But it is, to the best of my knowledge, accurate as of right now. So the first thing I want to, oh goodness. See, okay, there we go. Trying to view my slides and also not shut down the Zoom at the same time. So I think one of the things that people are most worried about right now is who is most at risk, because the people who were at risk are no longer the only group that is being targeted by ICE right now for enforcement. There have been a couple recent changes that really have affected the people who are subject to certain kinds of detention. So when I say mandatory detention, I'm going to mention it a couple times throughout this presentation. I mean it in a very specific way. It is part of the Immigration and Nationality Act. There's a specific provision in that gigantic statute that is a federal statute that goes through in really nitty-gritty detail all of the conditions under which people are subject to mandatory detention. And in that circumstance, if somebody is subject to mandatory detention, it means that ICE doesn't have the discretion to not detain them. So if ICE arrests somebody, they have to detain somebody if they fit into these qualifying categories. However, even though the statute in some of the situations hasn't changed, the interpretation of the law has changed. So ICE has changed the way that it interprets the law. And recently it said in a couple instances, oh, we don't think that the way we used to interpret the law, the way that we may have interpreted the law for a decade or 20 years or even longer, is the right way to interpret the law. We're going to change what we mean and who we think is covered by that. And so that is a way that the agency has made a lot of tweaks to really expand the number of people who are subject to mandatory detention. It used to be, so under the Biden administration, and until very recently, it used to be that the people who are most at risk and really subject to mandatory detention were people who had been convicted of serious crimes, so aggravated felonies, kind of multiple convictions of pretty serious charges. That is no longer the case. So the two major changes that have occurred in the past 8 months are anybody who has been arrested, charged, or convicted of certain theft offenses is now subject to mandatory detention. That went into effect in January, and it was part of the Lincoln-Riley Act, which added these certain offenses to the group of crimes that were subject to mandatory detention. What's really extreme about those is that it's not just somebody who's been convicted, right? Like, so it's not somebody who has been convicted of murder, for instance. It is somebody who has potentially only been arrested for a theft offense. So potentially a very minor offense, and potentially never even charged or convicted. So there's merely kind of an accusation of committing the offense. The other major change that has really expanded this was last month, when the administration reinterpreted the way that they're interpreting some of the provisions of the Immigration and Nationality Act, or INA, and expanded them to anybody who entered without inspection. So in many instances now, anybody who crossed the border between ports of entry who didn't get a check or an admission through CBP when they entered the country, who maybe climbed over the wall or walked across the border, they are now subject to mandatory detention. And so this hugely expands the number of people who are at risk of being detained. And again, in those situations, it's not somebody who, this is not somebody who has committed any sort of serious crime or been convicted of any serious crime. It is also not a situation in which ICE has discretion any longer to no longer detain that person. And so that is that is opening the door to detaining a huge number of people. The other kind of group of people who are also at risk of detention are people who are subject to um, or people who have final orders of removal. I want to note that in my slide here, it's it's configured such that it looks like anyone with a final order of removal is subject to mandatory detention, and that's not true. That should be not categorized underneath that. But people with final orders of removal are at risk of arrest, of risk, or at risk of being targeted. And that people with final orders of removal can vary in terms of their circumstances. So it might be somebody who ICE was unable to remove um, after they were initially ordered removed. And in those circumstances, they might have been given an order of supervision, and they might be attending regular check-ins with ICE. And that might have been the case for a long time. So people who have regularly been checking in with ICE under an order of supervision for many years, they may no longer be, when they check in, they may no longer be allowed to continue to not be detained. Similarly, people who have a final order of removal, but some sort of humanitarian protection. So, for instance, withholding of removal or protection under CAT, those are kind of humanitarian provisions that are similar to asylum, but they don't necessarily protect against removal to third countries. And so people who have those protections are now that the administration is expanding its deportations to third countries, those people are now at risk of removal as well. And as I mentioned earlier, this list is likely to change. It's also somewhat unpredictable. So people who might normally not be at risk of detention or arrest, people who under most circumstances there isn't necessarily any flag that would make, for instance, their attorney worry. I'm hearing a lot of stories that there are a lot of unexpected arrests. Okay, so I want to talk about ICE rights during ICE arrests. I think that there are a number of trainings and a number of really good resources available for what a judicial warrant is and what somebody's rights are during certain types of arrests. I'm going to provide, hopefully, the congressman's office with a list of resources, and I'm going to include some links to some of the organizations and some of the resources that kind of walk through that. There are a couple, including the Immigrant Defense Project, that have those resources in a ton of languages. And so they're very accessible and they're very easily understood. And it's something that somebody can have in front of them when they might need it. So if the kind of breakdown generally is if you're in somewhere where you have an expectation of privacy, a reasonable expectation of privacy, so if you're in your home, um, ICE or the government can't come barging in without kind of getting a check from a judge saying, okay, there's a really good reason that you need to be that disruptive, that kind of violent, and we're going to let you, after we've kind of like reviewed everything, we're going to let you do that. And that's a judicial warrant. It is a check by a third party, by the judge saying, okay, we understand why you're doing this. We think that you do have probable cause, and we think that it's warranted. No pun intended. In that circumstance, that's a process, and that's how any sort of normal criminal arrest would go. Because ICE is a civil agency, the constitutional protections aren't always as rigorous as they are during a criminal investigation or a criminal arrest. And that means that a lot of the people who and a lot of the rights that people are kind of used to in a criminal setting or expect in a criminal setting don't necessarily apply in ICE. In an ICE arrest or in ICE detention. And there are some regulatory restrictions around what ICE can and cannot do, and how ICE should and should not proceed in certain circumstances. Um, and there are some internal policies that ICE is supposed to abide by, but they aren't as robust, they aren't as rigorous as the constitutional protections. That's not to say that there aren't protections. That's not to say that that ICE has free reign to do certain things, but it is indicative of kind of the lower standards to which the civil immigration enforcement is held, and that can be really frightening in some circumstances, and it can be very difficult to address some of the issues that do come up, because even if they are a violation, the only way to address them is after the fact and in as part of the removal proceedings in immigration court, which I will get to in a moment. So if you're in public, you're in your home, ICE needs a judicial warrant, or they need some sort of exception. So they need like an emergency circumstance in order to go into your home to overcome that warrant. Otherwise, they really need a warrant. But everybody, for the most part, ends up leaving their home every day. And when you leave your home and you're in a public area, you have significantly less protections than you do inside your home. You don't have a reasonable expectation of privacy when you're walking down the street. And in those circumstances, ICE has the authority to make arrests with only an administrative warrant. Technically, they are supposed to, under the regulations, get a warrant unless they have an exception, kind of similar to the warrant exception that I was talking about previously. The exception is that they need probable cause, and they have to think that it is unlikely that they'll be able to obtain a warrant and before the subject, the target of the warrant, leaves and they're unable to find them again. We know that ICE does not rigorously apply that exception analysis. And many people end up getting arrested despite there not being a clear cut or a clear analysis of that exception. And it's not as forceful of a law because it's only regulatory. It's not, again, a constitutional rule in the same way that it would be if it was in criminal court. Because somebody who's walking down the street is in public, the warrant exception or the warrant requirement of a judicial warrant also doesn't apply. So it's not an invasion of your privacy in the same way that it would be if ICE was barging into your house to try to make that arrest. There are, again, a number of really good, detailed resources that go through this, and I'll add them to the resource list that the Congressman's office will hopefully be able to post alongside this afterwards. So what I am doing in this presentation, I'm kind of walking through the different stages of what happens. So before an ICE arrest to after an ICE arrest and detention, and kind of what the options are, and walking people through the process so that it's more comprehensible and more understandable. So during an ICE arrest, I think many people have probably seen some of the videos. It can get it is not necessarily a calm experience for anyone. But regardless, it's generally never a good idea to try to physically resist the arrest or to try to physically interfere with the arrest. And that's for a couple of reasons. First, practically, from my perspective as an attorney, if you are resisting arrest, that potentially adds criminal charges, and that's going to make your situation even worse. There have also been some instances where somebody who is resisting arrest, if they are physically resisting arrest, and something happens, they may end up getting charged with assaulting a federal officer, and then you have another criminal conviction or another criminal charge. That is, for your legal situation, not a good place to be. It can also result in an escalation of the violence that's being used. And so if, for instance, somebody physically tries to interfere in an arrest, that can escalate things to a place where it can get very dangerous for everyone, including, and most importantly, the target of the arrest, because it escalates the necessity for ICE to use force, or that's kind of the way that it is framed. So generally, physical interference is not a good idea. That doesn't mean that you can't do anything, though. So it's really important, and one of the things that can be most effective is recording. We know that ICE is not enjoying some of the press that they're getting around kind of what they're doing. And the motivating factor around a lot of that is the very obvious extreme violence, the extremity of the tactics that are being used, like having a mask, having full like combat gear for, arrests in the suburbs of, children. Recording is a really helpful way to document what's happening. It can be helpful if something were to happen and the person who is the target of the arrest needs to prove in court what happens, because there's no real way to kind of at the outset prevent things from happening. The way to address some of this is kind of after the fact in immigration court. Having evidence of what happened can be very, very effective in demonstrating why certain evidence might not be admissible or why they might be able to potentially dismiss things entirely. There are a couple of rules around that. Well, I guess best practices. Generally, you want to focus on the ICE officer. Any sort of license plates, badges, get their name. Because more ICE officers are covering their faces, that's no longer as effective as it was. but it is useful because you'll need to, or it'll be helpful to identify who the arresting officer is. You don't want to focus on the face of the target. That can be really invasive, and if the video ends up getting released, it can release their identity in a way that can really invade their privacy and make things more unsafe for them. Um, it's also if the person who's being arrested isn't known to the bystander, and the bystander is and there's nobody around who is helping the person who's the target, um, getting the name and A number of the individual who's being arrested, if they can remember their A number off the top of their head, that can be really, really helpful in figuring out what happens to them after the arrest. Because that's the information that's needed to put into the ICE detainee locator in order to track down where they're being held and what facility they're being held at. Generally, if somebody is the target of the arrest, if you're the target of the ICE arrest, it's important to let the arresting officers know a couple things. If you have minor children around, you can sometimes ask them to not arrest in front of the children. There used to be more rigorous standards around that, but those are no longer in effect. But it's still possible to make that request. Additionally, and something that, depending on what somebody's situation is, if you have any sort of medical needs, if you have any medications that you need to take, it's really important to tell ICE that and to repeat it if necessary. An example is somebody who has I've had like clients who are HIV positive, who, it's really important that they get medication every day. That is kind of the example of why it's really important to tell ICE of their medication so that they don't lose it, so that they continue to have access to it. Okay. So once somebody is arrested, after somebody is arrested, there's a whole process that ends up happening. Sometimes they'll be taken to a local jail, so a local facility that has usually a 287G agreement with ICE, and they might be held there for a couple days. It really depends on the situation at Batavia. Right now, most people who are arrested in upstate are taken, if they're not taken directly to Batavia, they're taken and held at a facility at a local jail for a couple days and then taken to Batavia. I haven't seen or heard of many people who have been taken directly to another detention facility. Once somebody gets kind of booked into Immigration and Customs Enforcement ICE detention, they can then be transferred to another facility. So just because somebody ends up in Batavia, it doesn't mean that they're necessarily going to stay in Batavia. It's very likely that they could be transferred to one of the larger detention centers in the South, or other locations. There have been some news reports recently of people who have been transferred, for instance, to a detention facility in Hawaii. They were not from Hawaii. They did not have any tie to Hawaii, but they were being transferred to a detention facility all the way in Hawaii. And it is within, generally, unless there is some sort of order or other kind of prevailing piece of law that's preventing ICE from doing that, ICE can generally transfer. It's within ICE's authority to transfer people anywhere in the country. And that means that people are maybe at risk of being removed from their support networks. It means that it may be really difficult for people to get in touch with their family. If they need any sort of help, it's going to make it a lot more difficult. They're going to be further away from any attorneys they might have. And it really heightens the difficulty it makes in contesting their removal and deportation. Because a lot of the detention facilities are in the South as well, particularly in some unfriendly circuits, so in the Fifth and 11th Circuit, the law in those two circuits are pretty, and they're not friendly to immigrants in detention, and it is more difficult to get out. It's more difficult to win a case, and so it makes everything a lot more difficult for people to actually contest their removal. And I don't think that that is an accident. There are a few ways to prevent that from happening, but the standards to making that happen are pretty high, and it requires a federal lawsuit, which requires an attorney, and it's not an easy win anyway. So I want to share this not because I want to add to the doom and gloom, but I do think that it's important that there is awareness around that, so that people are more oriented and understand what's happening if they do get transferred or if one of their loved ones gets transferred. Just to know that it is a common practice. It can be a very scary experience. It can be very disorienting. ICE doesn't always clearly tell people what's happening to them or where they're going. And they may be transferred multiple times in a row over a very short period of time. And it's a really scary experience. But hopefully if people know to expect that, it can be a little less terrifying should it happen to them. For people who have somebody who's been arrested and detained, the ICE detainee locator, which I'll include on the list of resources, I have linked it up on the slide, is the really only way to go about doing that. You will need somebody's passport information and or their A number. So on the previous slide I mentioned it's really important to try to get their A number. And that's the identification number that is used throughout the immigration system to identify the person in their case. So it's kind of like a social security number, just in terms of it's the code that the government uses to identify someone. However, it's not always easy the information isn't always correctly entered into the database, and so sometimes there may be typos. It's not always typo free. Sometimes there's incorrect information. So there are an increasing number of reports of people who have been held in some ad hoc facilities. So hotels or some of the newer detention facilities out of Florida, or people who are held in Guantanamo, where the detainee locator isn't accurately reflecting their location. And so that is something to be aware of. It's really messed up and that's not okay, but it is not entirely accurate. If somebody is at a facility, the best way to try to contact them is to contact the facility directly, to figure out what the way of contacting the person is, because it can change depending on the facility. There used to be free phone calls, and as of last year, my understanding is that those are no longer in effect. That was ended under the Biden administration. And it is very difficult for people to contact, even before it was very difficult for people to contact attorneys or family members or support networks if they were in detention. So there are the main way that people get released from immigration detention if they're not excuse me, I'm recovering from a cold and my voice is a little scratchy right now. Um, but the main way to get released from immigration detention is through a bond hearing. Some people will automatically get a bond hearing and you can request one, but generally you're only allowed to have one bond hearing. And so if you do request a bond hearing, it's best to do so when you're sure that you're going to have an attorney so that you can make your best shot at getting released. Um, because a lot of the people who are subject to the new mandatory detention rules, policies, are not eligible for for bond hearings. It means that it's going to be more difficult, and my guess would be that there will be fewer automatic bond hearings, and that people will have to request those more. That is speculation. That's nothing that I have specifically heard, but that is what I assume is going to happen simply because it's a new expansion of a group of people who otherwise would not be subject to detention, or at least not subject to mandatory detention across the board. And it means that they will not be eligible to get released. So that means if somebody crossed the border, if they entered without inspection and they're subject to mandatory detention, they will not be eligible for bond. There are ways to argue around that, but it's a high hurdle, and it will be somebody will be making that argument and trying to get released from immigration detention where they don't have access to resources, where they may get transferred away from their support networks, they may get transferred away from their attorneys. And so it's just heightening the difficulty in how challenging it will be to get released. The way that people can kind of get around that is to file a federal lawsuit. It's called a habeas corpus in federal court. But generally, you need an attorney to do that. And I would recommend always having an attorney to help you with that because it can be complicated. And again, you have a limited number of attempts. So you really want to make the best of the ones that you have. Um, the good news out of that doom and gloom is that there are some really great lawyers in upstate New York, out in Batavia, who are part of the Volunteer Lawyers Project of the Erie County Bar Association. And VLP, Volunteer Lawyers Project, does have appointed counsel or free counsel for certain qualifying individuals at Batavia or who have a substantial connection to New York. So if they're potentially transferred out of Batavia, that wouldn't necessarily mean that they would lose their attorney. And so that can be really life-changing in terms of getting out of immigration detention, in terms of getting a bond hearing, in terms of succeeding at that bond hearing. And so the VLP attorneys, I believe, are automatically at Batavia. And I'll add to the resource list their contact information so that people who are on the outside, who are their supporters, if somebody has trouble connecting with them, they'll be able to help make that connection. So when you enter immigration detention, you'll be assigned to a deport officer, DO. They will kind of be the person who is coordinating your deportation and your time in detention. So they will be they will be the best point of contact and best target for a lot of the advocacy that you can do for yourself. If you fear return to your home country, it's really important that you tell your DO that repeatedly. One of my friends would say, like, tell everybody, like, if you're afraid to return to your country, like, tell the cook, tell the person washing the floors, like, tell everybody who has any sort of authority, no matter how limited in that facility, that you are afraid to return to your country. That's particularly important now because the policies have changed such that it is no longer mandatory for ICE to ask. So it used to be, until very recently, under most circumstances, if somebody was going to get removed, ICE would have to ask if they feared return to their home country. Now, ICE cannot ask in a lot of those circumstances. That's particularly true for third country removals. So for people who are not able to return to their home country, um, who ICE wants to remove to a third country, they want to deport them to a third country, maybe entirely across the world, maybe a country that you've never heard of before. You don't know what the circumstances are like there. Um, and in many of the countries um, that are currently agreed with the administration to accept third country removals are not in the most stable or most or where people's rights are protected. If you're in a situation where you are fearing that you could be removed to a third country, it's really important to articulate, to tell anybody, any ICE officer, your DO, whoever you encounter, that you have fear of being returned because or being removed to that country because there is very limited, if any, process that's going to happen. There does not need to be a formal process. There doesn't need to be a formal immigration court hearing. The Supreme Court has recently decided that and basically signed off on ICE deporting people to third countries that they've never been to, and with very limited oversight or opportunity to contest that process. So it's really, really important if you have any sort of fear of return to your home country or to a third country to articulate that repeatedly whenever you can. So one of the things that I know is often really difficult for people is how to find resources. And that's particularly true when you're looking for resources, you're looking for help in somewhere that you are not familiar with. You're not maybe from the area, you're not from Batavia. How do you find resources out in Batavia? How do you find an attorney out there? There are a couple different routes you can take. So as I mentioned, VLP does offer qualifying individuals some representation. So that is always going to be a really great route. They're very talented attorneys, and they do something that's really like an amazing job doing something that's really difficult. There are some other nonprofits that might be able to help. Immigration Law Help is part of probono.net, which is the kind of organizing website for a lot of different nonprofits. They have a list of different organizations, different immigration help organizations throughout the country. You can go to their website, you can click on the state that you are in if somebody's transferred to a different state. If somebody, for instance, is transferred out to Hawaii, you can pull up Hawaii and see if there are any nonprofits out there that are going to be able to help with immigration and people who are in immigration detention. It's not entirely comprehensive, it's not entirely foolproof, but it is a really good starting point. Generally, you can, a lot of organizations are also able to provide referrals, so you can call the organizations that you are able to find, and then they may be able to suggest other organizations that you can go to. If you can afford a private attorney, you might also be able to go that route. The American Immigration Lawyers Association is the kind of largest bar association of immigration attorneys in the country. They're very well respected, and many attorneys are members. They have a pretty robust referral service, and you can locate that at alalawyers.com. Um, it's not foolproof, but it will connect people to to attorneys who are invested enough in their practice to be members of ALA. And so that is another way. That is another way to find legal help. I want to mention it's really important to only get help from an attorney or a DOJ accredited rep. So a DOJ accredited rep is somebody who's licensed by the Department of Justice to provide assistance under the supervision of an attorney, but they're licensed to provide assistance to people in immigration court or in affirmative proceedings in front of USCIS. Sorry, I was trying to find something. It can be very tempting. It can be very difficult to find immigration help. And it can be really tempting to get help from somebody who calls himself a paralegal, somebody who calls himself a notario, or somebody who is like, hey, I did this for my cousin and I know exactly what I'm doing and I'm going to help you get through this too. A lot of people end up with in bad situations because they take bad legal advice from people who aren't licensed and don't know what they're doing. Paralegals who are working under or assisting an attorney is one situation. A paralegal who's kind of out on their own is not going to be qualified and is not going to be licensed to provide immigration assistance or provide immigration legal assistance. That is different from having a friend help you fill out a form. A friend can help you fill out a form, a friend can interpret for you, but they can't tell you what you should do as far as your legal situation. That's providing legal advice. So interpreting the law, saying, I think that this is the right way to go, that would be providing legal advice. There are a couple ways to vet the legal help that you get. When you find an attorney, how do you know that they're really an attorney? You are entitled to their bar information. So you are entitled to having them affirm to you to show you that they are in fact licensed to practice law. Because immigration law is federal and it's practiced in front of the Executive Office for Immigration Review, that's the Immigration Court section, or in front of U.S. Citizenship and Immigration Services, or USCIS. Those are federal agencies. And so a lot of times it's possible for immigration attorneys to only be barred in one state or territory, one jurisdiction. And then they might live in another, and they might be able to practice based on the other state's licensing that they have. The licensure depends on the state where they live and whether that state requires them to be licensed as well. But for instance, you might be barred in Michigan and you might live and work in New York. And because you're only practicing federal immigration law, that is okay. But you're still entitled to know that your attorney is licensed, that they're barred. And generally you can find that they should be able to tell you that. And you can find that online if you are kind of looking them up ahead of time before you want to, before you end up meeting with them, or if you're just kind of at the very outset of finding an attorney. Most states, almost all states have searches for licensing. So if you were to click on this New York link, you would be able to, for instance, look up Lauren DeRosier and you would be able to see my bar license and you would be able to find out that this coming fall I am due to renew, which means that I have to resubmit and certify a renewal application to keep my license current. It's really important that you do that and check to make sure that your attorney is actually an attorney and actually licensed, and that will be a process to do that check. I mentioned DOJ accredited reps earlier. Again, they're non-attorneys who are allowed per the DOJ to, under the supervision of an attorney, practice immigration law, but they are only, that's limited to the people who are on these lists. So the DOJ releases these rosters, and this is the list of who is actually accredited. So the organization has to be accredited and the individual has to be accredited. Only nonprofit organizations are accredited, and those are both at this link. The other thing that I didn't put on here, but it's kind of one of the most important things is if you hire an attorney, you are entitled to have a contract that indicates how much, if anything, you're paying them. So it has to be really clear, and you are entitled to that, and what they're providing to you. So if you have a discussion with an attorney and you end up hiring them, it's really important that they give you some sort of engagement letter, some sort of retainer agreement, to identify what they're doing for you and what you're paying them, if you're paying anything, and to lay out those terms really clearly. An attorney has the duty, have an ethical obligation to communicate fully with a client, and that is not waived if somebody doesn't speak English. So if I have a client who speaks Portuguese and I don't speak Portuguese, I, as the attorney, would have a duty to make sure that my Portuguese speaking client understands everything in the contract and anything that they have in terms of questions about the representation. They would be on me as the attorney to make sure that that happens. So it's really important that people understand that they have the right to insist on understanding everything about their case, and making sure that they understand everything about the agreement that they are making with the attorney to represent them. You can also always fire an attorney. So if an attorney is not working for you, if you end up finding a different attorney and really liking them, you can always switch attorneys. There are some restrictions around unpaid bills and file retention, but that isn't relevant in terms of the actual representation. Like you can always move on to a different attorney, and it's important that you feel comfortable being able to ask things of your attorney and being able to understand and have things explained to you in a way that you understand, in a language that you understand. Those are really, really important things. And I think people get intimidated by attorneys or they feel like they don't have the right to ask. And it's really, really important that that everyone knows that they have the right to have those assurances. And with that, I have finished with my presentation. I'm running out of my voice. But Cora, do you have any questions?
Lauren, first and foremost, thank you. Very informative. I wish we had more time. I really do. And we will have to bring you back. I sound like we're a night TV show. So we'll have to bring you back
I
so we can have more of a discussion. I do have one question. I know we're already into the second hour, but if I could just ask this one question, and if it's not an easy answer, I apologize, but one question, and again, everything that you shared, absolutely informative, and thank you for allowing us to have this live on the Congressman's website, and especially for the information that people can go and see and then use. My question, Lauren, is family and friends, right? Know their rights. What would you say would be one of the first things that family and or friends or loved ones do when they know that their loved one has been picked up by ICE? What's the very first thing that you would suggest they do?
um I think it depends on like how close. So like if it's immediate family, right? Let's say it's a partner or a parent. I would definitely pull up the ICE detainee locator and try to find them, assuming they don't have an attorney. If they have an attorney, call the attorney right away. It's much easier to get things done sooner rather than later. Attorneys want to know about things right away. So if they do have an attorney, call the attorney ahead of time. Make sure that you have the contact information for the attorney and call them right away. The second thing is to look at the ICE detainee locator. And sorry, my voice is starting to go. But look at the ICE detainee locator and try to figure out where they are.
Okay, thank you. Thank you for that. And I won't push your voice anymore. Okay, but thank you so very much. And I really think we need to do this again. I think there's so much more out there. And as you had stated in the beginning, things change all the time. And I think to help our constituents and anybody who happens to be listening, that to stay on top of things, stay abreast of what's going on, that too is very important so that you can not only know your rights, but exercise your rights. And on
I would
that,
love to come back anytime. I'm
love,
honored.
love to have you. Thank you. Thank you so very much. And this is where we will end.
Thank you so much. Take care.